Thanks very much. Before the Health Minister came, we were right in the middle of Ms. Kleinberg providing her answer to a subject that both Senator Jaffer and Senator White touched on here in this particular portion. But Ms. Kleinberg, when you were indicating that answer earlier, you were saying, well, you know, this, of course, the physician-assisted suicide section where someone potentially receives a prescription 2 or 3 years before, and Mr. Paragraph, earlier you indicated that that was a hypothetical, but it was a hypothetical that we posed at the briefing yesterday, and your official indicated that that was a valid hypothetical. So I guess what I'd pose to you is somebody in their household or some unscrupulous person, unfortunately, may be potentially influencing that person or even doing something worse than that, and you'd never know because there aren't any additional safeguards required in that circumstance. And earlier when you were responding to one of my colleagues here, Ms. Kleinberg, you indicated that you referred to U.S. state law for these sorts of things, but of course the U.S. state law does require terminal illness in those few jurisdictions that they have this, and also end of life. So it probably wouldn't be a situation of you know, that lengthy of a time frame. So I'm just wondering if you could provide a little bit more information than you provided earlier. Ms. Kleinberg.
Well, I mean, I agree with the comments of Mr. Paragraph, and just to clarify, before the prescription is provided, all of the eligibility requirements must be met. So this is a person who has been found by 2 healthcare practitioners who are qualified to make the determination that they're on a path towards the end of their lives. How long that might take, I don't know that. You know, these are hypothetical questions that we're not in a position to answer. In terms of unscrupulous individuals pressuring or taking advantage of a person in those situations, there absolutely remains criminal prohibitions that are very serious in nature that would prohibit that sort of conduct. So any person who counsels or influences or tries to encourage or incite a person to take the drugs themselves would be committing an offense for which there's no exemption provided. That offense is punishable by 14 years in prison. Any person who takes the drugs and somehow attempts to administer them directly to the person would be, in fact, causally responsible for their death and would be could be charged for culpable homicide, specifically murder. So that's what the criminal law can do. The criminal law can prohibit these forms of conduct.
And does, I agree with that. It's just that hopefully in this regime we would know about those sorts of things. I need to just move on briefly to Mr. Pentney. When you were earlier appearing with the Justice Minister, you both indicated that Canadian provinces could disallow nurse practitioners from providing assisted suicide, despite the fact that your bill provides either doctors or nurse practitioners. And I was just wondering if you could point to me which particular provision of the bill provides that. Just in having a quick look myself here after you gave that answer, I'm wondering if you're just referring to the definition of nurse practitioner.
That's exactly the definition, and the reference to means a registered nurse who, under the laws of a province,
is entitled to practice as a nurse practitioner. It doesn't
at page
limit
7,
it for this.
I'm sorry, Senator, at page 7, subsection 7, medical assistance in dying must be provided with reasonable knowledge, care, and skill, and in accordance with any applicable provincial laws, rules, or standards.
Okay, so that's the only parts, is just those two?
Those two, yes.
Okay.
Yes.
So again, it just, in a lot of ways, it seems like this particular bill is putting things off on the provinces or regulatory bodies to take some really significant steps, and we could have quite a patchwork of situations across the country. And are you concerned about that?
I think that, as the ministers have made clear, the government's intention by exercising the criminal law power, which is a federal power and applies from coast to coast to coast, is to establish a baseline or a floor, but recognizing that Canada is unique in the world as a federal state, where we are exercising a criminal law power in respect of a medical procedure where, as the Supreme Court of Canada has recognized in a series of decisions, is an area of federal and provincial jurisdiction. The government's commitment is to try to ensure a degree of uniformity, but recognizing that different provinces and territories have a role to play in respect of the regulation of medical practitioners and in the kind of the professional conduct and expectations and standards and norms and guidelines. We've seen a number of provinces starting now to exercise that jurisdiction. Quebec led the way. Other jurisdictions now are out with some guidelines. Some courts in respect of this interim period of exercise guidelines. So the government would seek to ensure a degree of uniformity, and we're working actively with provincial and territorial officials to implement this. But the Supreme Court of Canada has also made clear that in respect of the federal power, there are limits. So from the assisted human reproduction decision from the Supreme Court of Canada, it clearly prescribed limits on how far the federal government can go in prescribing especially professional practice. So we are unique in the world in trying to work this through, but the government's commitment is to try to achieve a reasonable degree of uniformity, but recognizing that different provinces now treat nurse practitioners somewhat differently, have some differences. Those things will continue.